Mr. DRUMMOND, I have had enough of this. Open this door right now. You think you can just ignore this HOA? I will make your life hell until you comply. Every single day I will stand on this porch until you sign those papers. 5 loud KNOCKS. You need to get off my property or I'll over this whole community. Homeowners Association President Dorothea Grange of Willamere Commons had built a reputation for getting exactly what she wanted. Fines collected, residents silenced, complaints quietly swept away. So when a house just outside her HOA's boundary line refused to fall in line, she decided the boundary was more of a suggestion than an actual legal fact. She showed up outside homeowner Ezra Drummond's house 4 separate times in a single week, took photos of his property, pounded on his front door hard enough to crack the handle, and told him through the closed door that the HOA would push for foreclosure if he didn't get in line. What she had no idea about was that Ezra had a Ring camera mounted on that exact door, a time-stamped photo of the cracked handle, a written log of every single visit she'd made, and an attorney who had been waiting a long time for a case exactly like this one. A case with enough hard evidence not just to win in court, but to get Dorothea personally ordered to pay every cent of the damages, legal fees, and court costs straight out of her own pocket. Before we go any further, tell us what city or country you're tuning in from. Drop it in the comments. We love seeing where our viewers are watching from. And if you believe your home is your castle, and no HOA president armed with a clipboard and a god complex gets to dictate what happens on your own property, hit that like and subscribe button and come join us here on Karen on Hedge. Willamere Commons sits just off Greenhouse Road in northwest Houston, Texas. 52 single-family homes, perfectly manicured lawns, matching mailboxes, and an HOA that charged residents $2,800 a year just to be told how long their grass was allowed to grow. Dorothea Grange had run the community for 6 years, and in those 6 years, she'd fined residents over paint colors, written up violations for holiday decorations left up 3 days too long, and bullied 2 separate homeowners into compliance using lien threats that her own HOA attorney had privately warned her were legally shaky at best. Nobody had ever really pushed back. Dorothea had mistaken that silence for respect. It wasn't respect at all, it was exhaustion. At the far eastern edge of Willamere Commons, right where the development's boundary line cuts across the corner of Sycamore Bend and Millbrook Drive, sits a single property the HOA does not own, does not govern, and has zero legal authority over. The house at 7742 Millbrook Drive sits 14 feet outside the recorded HOA boundary. A fact spelled out clearly in the Harris County Appraisal District records, in the property deed, and in the original 1998 subdivision plat filed at the Harris County Clerk's office on Preston Street downtown. 14 feet, not a gray area, not open to debate. A hard legal line drawn on a map and filed permanently in a government office. Ezra Drummond, 38, bought the house on a Tuesday in March and had the keys in hand by Friday afternoon. He was a white man with a solid, straightforward build, sandy hair starting to gray at the temples, and the kind of calm, unhurried energy that comes from learning long ago that most problems have a solution if you're patient enough to find it. He worked as a senior project manager for a commercial construction firm out of the Galleria district, had owned one earlier property in Katy, Texas, and through years in construction had picked up enough working knowledge of real estate law to read a property deed, understand a boundary survey, and spot when someone was overstepping their authority. He wasn't a lawyer, but he knew enough to know exactly when to call one. He was out in the driveway of 7742 Millbrook Drive, unloading boxes from his truck on a Saturday morning, the first time he noticed her. A woman standing at the edge of the sidewalk across the street. Neat cardigan, clipboard in hand, watching him with the kind of focused attention you'd use to take inventory. He figured she was just a curious neighbor. He nodded at her. She didn't nod back. She wrote something down on her clipboard and walked off. 3 days later, a welcome packet showed up in his mailbox. Official Willamere Commons HOA letterhead, full color, laminated cover sheet. Inside was a 12-page community standards booklet, a direct debit form for annual HOA dues, and a letter signed by Dorothea Grange, HOA president, welcoming him to the community and informing him that his property was now subject to all HOA rules and regulations, effective immediately. Ezra read it over at his kitchen table. Then he pulled up the Harris County Appraisal District site, located his property record, cross-checked it against the subdivision plat, and confirmed exactly what he'd already suspected. His property wasn't in the HOA. It never had been. It wasn't subject to a single rule, fine, or regulation that Dorothea Grange had any authority to enforce. He slid the welcome packet back in its envelope, set it on the counter, and went back to unpacking boxes. He'd barely lived in the house 2 weeks. He wasn't looking for a fight. He figured one polite, clear conversation would settle the whole thing. He figured wrong. Dorothea Grange didn't do polite conversations. She did compliance. And Ezra Drummond had just become her newest target. Ezra wrote back anyway. He kept it short and professional. One paragraph laying out that his property at 7742 Millbrook Drive sat outside the recorded Willamere Commons boundary, citing the Harris County subdivision plat by file number, and politely declining the HOA membership packet. He mailed it off and considered the matter done. Dorothea Grange got that letter, read it, and apparently decided it didn't mean a thing, because 3 days later, a second HOA notice showed up at his door. This time citing him for an unapproved fence post visible from the street, and threatening a $350 fine if it wasn't removed within 14 days. Ezra didn't have a fence. He had a wooden post holding up a bird feeder. He stood in his driveway, holding that notice for a long moment. Then went back inside and called Idris Baptist. Idris was a real estate and civil litigation attorney working out of a firm on Westthamer Road in Houston. Someone Ezra had met 3 years earlier during a construction contract dispute. He was sharp, thorough, and the type of lawyer who got quiet whenever he read something that genuinely caught his interest. He got very quiet reading Dorothea's letters. Then he told Ezra to stop responding to her directly, to document everything from here on out, and to leave the rest to him. Ezra agreed. What neither of them quite expected was how fast Dorothea would make things worse all on her own. She started parking outside his house, not once, not casually, but deliberately and repeatedly. A dark sedan camped along the curb on Millbrook Drive 2, 3, 4 times a week. Notepad out, photographing his property, tracking who came and went, jotting things down with the focused intensity of someone building a case. His neighbor Odessa Voss, who lived 2 doors down at 7738 and had watched Dorothea operate from behind her kitchen window for 5 years, knocked on Ezra's door one evening and told him flat out. She did this to the Pattersons 2 years ago, until they finally just paid her to make her go away. Don't pay her a dime. Ezra thanked her, logged the date and time of her visit, and added her name as a potential witness. Then Dorothea started knocking. The first time she showed up at his front door, it was a Tuesday morning, 7:45 a.m., before Ezra had even left for work. She knocked hard. Not a polite knock, the kind of knock that says, "I'm not asking." Ezra opened the door, told her clearly and calmly that his property fell outside her jurisdiction, and that any further communication needed to go through his attorney. Dorothea ignored that entirely and told him the HOA would slap a lien on his property and start foreclosure proceedings if he didn't pay his outstanding dues and remove the fence violation within 30 days. Ezra shut the door. She knocked again. He didn't open it back up. The second visit was worse. She came back 4 days later, and this time pounded on the door so hard and so long that the door handle housing cracked along the left side, the handle itself pulling halfway loose from the plate. Ezra heard it happen. He opened the door, looked at her, then looked down at the broken handle. Dorothea didn't say a word about it. She just shoved another violation notice toward him and told him the HOA board had voted to escalate his case. Ezra took the notice, closed the door, and immediately photographed the cracked handle from 3 angles on his phone. Time-stamped close-ups, the split in the housing clearly visible. Then he called Idris. Idris told him to get the handle repaired, hold onto the receipt, and send every photograph his way. He also told him something Ezra had already started to suspect. Dorothea had crossed the line out of harassment and straight into criminal property damage, and combined with the surveillance, the bogus notices, and the fraudulent letter she'd sent his mortgage lender the week before claiming he was in breach of community standards, she had just handed them everything they needed. Ezra hung up, glanced at his front door, and for the first time since moving into 7742 Millbrook Drive, let himself smile, small, quiet, satisfied. Idris Baptist skipped the strongly worded letter entirely. He filed suit. That was the first thing Dorothea never saw coming. That instead of negotiating, instead of politely asking her to stop. Ezra Drummond walked straight into the Harris County District Court on Congress Avenue and went on offense before she ever made good on a single threat. The filing was extensive. Harassment, stalking conduct, criminal property damage, fraudulent misrepresentation to a mortgage lender, intentional infliction of emotional distress. Every single count came backed by documentation so clean and thorough that Dorothea's own attorney reportedly asked her, privately, how she'd let things get this far. She didn't have a good answer. The cease and desist hit her door the same morning the suit was filed. It ordered her and the Willamere Commons HOA to immediately stop all contact with Ezra Drummond, withdraw every notice ever issued against his property, and cut off all communication with his mortgage lender. It also spelled out, in plain language, that 7742 Millbrook Drive had never sat within the HOA boundary, and that every single action she'd taken against that property over the past several months had been illegal, starting with the very first letter. In court, Idris laid it all out without any drama. The Harris County subdivision plat showing the boundary line, the time-stamped photos of Dorothea's car parked outside the house on 14 separate occasions, the cracked door handle alongside the detached repair receipt, the letter she'd sent to Ezra's mortgage lender, which the lender, fortunately, had flagged and never acted on. The full violation log Ezra had kept from day one, written down with dates, times, and descriptions. Odessa Voss took the stand and told the court exactly what she'd watched unfold from 2 doors down over several months. Bertram Fitch, Dorothea's most loyal board member, sat in the 3rd row staring intently at the floor the entire time. The judge didn't deliberate long. The ruling came down hard, and it came down on everything. Dorothea Grange was found liable on every single count: harassment, property damage, fraudulent misrepresentation to a third-party lender, and intentional infliction of emotional distress. The judge ordered her to cover Ezra's full legal fees out of her own pocket. She also paid damages for the months of surveillance, the repeated unwanted visits, and the emotional toll of being threatened with foreclosure over a property she never had any legal claim to in the first place. The cracked door handle repair bill, modest as it was, got tacked onto the total just for the principle of it. Every dollar came straight from Dorothea personally, not the HOA fund, not some shared account her. The Willamere Commons HOA was ordered to issue a formal written statement, permanently filed at the Harris County Clerk's office on Preston Street, acknowledging that 7742 Millbrook Drive sat entirely outside their jurisdiction and was never subject to any HOA rule, fine, lien, or enforcement action of any kind. That document sits in the public record to this day. Anyone can pull it up. The state HOA Regulatory Board opened a separate investigation into Dorothea's conduct over her 6 years as president, and found that the intimidation tactics she'd used on Ezra were nothing new. 2 earlier homeowners had gone through the exact same thing and had quietly paid rather than fight back. Those cases got flagged for review. Facing state oversight, a damaged reputation, and a reserve fund now under close scrutiny, the HOA board voted to remove Dorothea as president within 10 days of the ruling. Bertram Fitch, who'd sat through the entire trial in the third row without meeting anyone's eyes, voted to remove her too. Dorothea left the board without a single statement. No apology, no acknowledgement, nothing at all. Ezra went home to 7742 Millbrook Drive, turned the brand new door handle, paid for by Dorothea's own damages check, and walked inside. If you've ever had an HOA try to control something they had no right to touch, drop your story in the comments below. We read every single one.